It's showtime.
People should not be afraid of their governments. Governments should be afraid of their people.
You know, the right to bear arms is because that's the last form of defense against tyranny.
Washington is fundamentally corrupt. There are more words in the IRS code than there are in the Bible.
Made in America, heard round the world. You're listening to Blunt Force Truth. I'm Chuck Woolery, along with my co-host Mark Young. And we're back to the Constitution, right?
We are, Chuck. This is part of our continuing series on learning the Constitution with Professor Adam Winkler, who's professor at UCLA School of Law. And he is the author of the book, We the Corporations, amongst many other books. Professor Winkler, welcome to the show. Welcome back.
Welcome.
And I want to remind people to go back and look through the archives. If this is the first time you're hearing one of our Constitution shows that we do every month, go back to the archives and start listening to them from the beginning. They are amazing. Professor Winkler does an incredible job.
Unbelievable.
So we have already gone through all the articles of the Constitution, and today we're moving on to the amendments. And we're going to cover Amendment 1 and 2 today. But, Professor, before we do that, maybe you could explain to us, why did we have amendments to a brand new document, and why are the first 10 amendments referred to as the Bill of Rights?
You know, that's a great question. Guys, thanks so much for having me back on. It's always a pleasure to come talk to you and talk to your audience about the Constitution, and especially when we get to the Bill of Rights. You know, the Constitution has two basic parts. It's got the structural components of the Constitution, Articles 1, 2, 3, 4, and 5, etc., that set out the powers of the executive branch, the judicial branch, and of Congress. But so much of what we really associate with the Constitution comes from the second part of the Constitution, which is the amendments, things like the Bill of Rights, amendments that have been added to the Constitution that really go very far in protecting our most fundamental rights and freedoms. When Madison wrote the Constitution, he only wrote it with the structural provisions, and his vision was that liberty would be protected because government power was divided. And because we had this federalist system with states and the federal government dividing power, and at the federal government we had power divided between the three different branches of the federal government, Madison thought that those structural limitations were the best protection of liberty you could have. And when the Constitution was proposed to the states, many states liked those provisions, but they were fearful that Madison's prediction was wrong, that these structural protections weren't enough to protect people's fundamental freedoms, and they wanted to add a series of amendments to identify and clarify the limits on the federal government. And thus, the Bill of Rights was born.
So this was actually people's concern. So as an example, like the Second Amendment, they would have been concerned about their recent history with King George trying to take weapons away from the Revolutionary, army. So these were the people's way of safeguarding, of making sure that these freedoms were so well documented that there couldn't be any controversy.
I think that is part of the idea. The anti-federalists, so Madison and those who wrote the Constitution were generally called Federalists, and those who opposed the Constitution as originally proposed to the states were the anti-federalists. And the anti-federalists thought that the federal government was going to likely grow too big and too strong and too powerful. They may have predicted right, I guess, 200 years too early. Yeah. And they thought it was really essential that we have a document that lists out the rights. And you're right, the rights that they sought to protect were the rights that the founders had thought were really, really important, in part because of the battles that they had with England. And there were states that said, hey, we'll ratify the Constitution as it is, but we recommend and we ratify with the condition that some amendments to the Constitution be considered. And states sent back to the federal government, to basically the Constitutional Convention, if you will, sent back notes saying, hey, look, we think you should add these 4 provisions to the Constitution. And several states said you should have protections for the right of citizens to bear arms in defense of the free state and the militias. And so these provisions were modifications. And surprisingly, Madison opposed the Bill of Rights originally, but ended up writing it and supporting it for ultimate passage of the Constitution.
Let me ask you a fundamental question that maybe everybody knows and I don't, but just to clarify everything, what was a Federalist and an anti-federalist?
Right. Well, so remember the story of the framing of the...
Like, was George Washington a Federalist or an anti-federalist? Who are these people?
Sure, right. So these were, America has always been beset by opposition and two political groups. And at the founding era, there was, after the Articles of Confederation, our first Constitution was adopted after the Revolution, but it proved pretty ineffective. And it was pretty ineffective because the states had so many rights that they kind of treated each other like they were foreign nations and imposed trade restrictions on each other. And there wasn't a kind of cohesiveness. And many of the founders, like George Washington, like James Madison, like Thomas Jefferson, they were quote unquote Federalists in the sense that they wanted to expand, recreate the Constitution, if you will, to create a Constitution where the federal government had more power than it had under the Articles of Confederation, so that we could have more of a sense of unity and we could have more cohesiveness in the nation and fewer trade barriers and problems. And so George Washington was a Federalist, Madison was a Federalist, Jefferson ultimately, although he didn't participate directly in the debates over the Constitution because he was the minister to France at the time, he supported the idea of a stronger federal government in the founding of a Constitution. And some of the anti-federalists, there were some founders who were a lot less well-known who were anti-federalists, but they've proven to be pretty influential over time.
So now we know that the states had more power than the federal government at that time before they, everything switched around. Now, and their big fear was the federal government would have too much power. And so here we live in today's time where the federal government seems like it's got all the power. So we are so beyond that idea of the states having any power or very little power at this point because the federal government has usurped most of it. What happened? How did that happen that the states lost all their power? I mean, besides the 17th Amendment and things like that we understand, but there are many other things too, aren't there?
Well, yeah, there's a long history in which states lost their power. And one of the primary ways they lost their power was a bunch of them decided to commit treason and declare war on the nation and fought a civil war. And that resulted after the Civil War in the passage of constitutional amendments like the 14th Amendment to the Constitution that we'll get to in future episodes. And one of the things the 14th Amendment does is it really restricts the power of states. And it does limit the ability of states to violate people's fundamental rights. One of the things to really recognize is that the Constitution's also been amended in those years. You mentioned the 17th Amendment. Right. American people have really sort of, in many times, fought to expand the power of the federal government because they want the federal government to do things for them that the states just wouldn't do.
I've always thought, and you can correct me if I'm wrong, because I really don't know whether I'm right or wrong. I've just felt this, that after the Civil War, we just kind of lost our way as to who we were. And out of that has come all kinds of, amendments and things that we probably wouldn't have done. I mean, some of them are good, some of them are not so hot. But we just kind of lost our way after the Civil War. It was almost our identity as a nation kind of just dissolved to a certain extent. I don't know for how long or whether it's always been that way and just continued to decline. Or do you agree with that? It just seemed like we were just so far apart in so many ways. And I don't know.
Well, I don't know. I'd like to think that the America that existed before the Civil War was not the America we'd want to have today, of course.
Well, of course not.
And of course,
I don't mean that. I don't mean it was after that conflict of North and South. I mean, I realized, that was a bad time in our history. Slavery was a bad time in our history, and those things were corrected. But after that, it just seemed like we had a tough time getting our footing back.
Yeah, well, I think that, it's true in the sense that we fought the Civil War, and in many ways we fought it for nothing. We freed the slaves, but ended up with Jim Crow laws because we didn't really have the commitment to ensure the equality of people regardless of race at that time. It took another 100 years for the promise of the 14th Amendment really to come alive. And one thing that's important to think about in terms of the scope of history, too, is that when the founders wrote the Bill of Rights, these first 8 provisions of the Constitution, sometimes referred to as the first 10 provisions, but the Articles, Amendments 9 and 10 are not really read to protect substantive individual rights like the freedom of speech does, like the First Amendment protects the freedom of speech. But these were limitations. The Bill of Rights was a limitation on the power of the federal government only, and not a restriction on the power of state and local governments. If you read the First Amendment, for instance, it says Congress shall pass no law abridging, say, the freedom of speech. It doesn't say anything about the state of Massachusetts or whether the city of Atlanta can restrict free speech. And in the first century of before the Civil War, what we saw is that many states did violate these fundamental rights. We think of these as fundamental rights that belong to the individual against any government, but it really wasn't until the 20th century when the Supreme Court began to really read these rights to protect against state infringement too.
Now, Professor, how important is it for people who really want to learn the Constitution to read the Federalist Papers and the anti-federalist papers?
I think reading the history of the drafting of the Constitution is really important, especially if you want to get a sense of what the original understanding of the Constitution was. I do think that anyone who reads those political tracts, though, should remember that that's what they were. They were documents that were for political purposes, that were designed to persuade and convince people, and they're not necessarily objective, authoritative assessments of the meaning of the Constitution. They were designed to win votes, and just like we today often mistrust speech that's designed purely to get our votes, I do think when we look back at those historical materials, sometimes we have to look at them with a bit more of a grain of salt. What were the authors of the Federalist Papers trying to do? Not just give an objective account of the Constitution, but persuade people to vote for it.
And the anti-federalist papers, aren't those really more of a collection of what would be newspaper editorials of the time?
Yeah, there are collections of anti-federalist writings that are largely pamphlets or newspaper pieces or speeches that were given that were later written down. And they talk about how we need to protect against federal tyranny. That was the debate that Chuck really mentions, the power of the states versus the power of the federal government. That's really been a central battle from the very, very get-go of America. And the Bill of Rights was a product of that fight among the founders.
Well, let's get to the First Amendment. And once you get through it, I have a couple of questions I'd like to ask about that. So the very First Amendment, we all seem to think we know everything about it. It's freedom of speech and attack.
Yeah, let me read it real quick, Chuck, because it's such an amazingly short statement, but it is so debated, such as the second one. So the first one is, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So it seems it's quite short. But Professor, there's just so much there, isn't there?
Well, it is. This is a short provision of the Constitution, but maybe the most important provision we have. It respects so many important rights, from freedom of speech and freedom of the press to freedom of religion and free exercise of religion. And also the right to petition your government for redress of your grievances is an important principle of democracy. The idea that you can go and complain about how government is treating you without retribution and seek to get government to change its mind. Now, and these are really important rights. This protects a whole zone of privacy, if you will, and personal conscience, where you can believe what you want, you can say what you want, and you can fight for the policies that you want, regardless of whether the government thinks they're a good idea or not.
Let me give you an example of something that's happened recently that's going on right now with a lawsuit. And that's this kid who was in Washington. And what's his name, Mark? Do you remember? That stood up against the...
Yes. What was that boy's name? Go ahead, keep going. I'll look it up.
Well, anyway, he, and it was reported by CNN, MSNBC, and ABC. All the mainstream media reported it, and they misreported the whole thing because they didn't have the whole story. But by doing it, they defamed this kid who's 16 years old and basically ruined his reputation and his future. I mean, just literally took it away from him. And that is under the freedom of the press. should the press have the freedom to do something like that?
His name is Nick Sandmann.
Yeah, Nick Sandmann. That case that's now before, I guess it's CNN and Washington Post. But I mean, that was so egregious with this kid once everything was found out that everybody jumped on it to begin with. They were all wrong, and they didn't really retract or apologize for being wrong. But that's beside the point. They still hide under or say, well, this is our First Amendment right to be wrong too. Do they have any responsibility to report, and when I'm talking about the press, to report, factually to people, or can they just make it up as they go or misreport or whatever?
Well, the truth of the matter is the Supreme Court has said that the freedom of speech and of the press is a very, very broad protection, and that it does not allow the government or prosecutors to come in and say, this is true speech, this is false speech, you can't pursue this idea, you can't say this about that person. If someone is a totally private individual, then they have somewhat more protections against false and reckless speech. But once one goes out into the public and becomes part of a participant in a public event, well, then the court is even more likely to defer to the media, because the idea is, one of the reasons why we have the freedom of speech is so that we have an open marketplace of ideas, and that false ideas can be pursued and tested, and that the only way that the good ideas are going to come through is if government doesn't pick and choose and punish the people that it disagrees with. Honestly, the press is not likely to find much, have to pay an award to Mr. Sandmann, largely because I can't speak to the facts of that particular case, having not followed the legal wrangling with very closely. But we know that the background principles that we're working with are extensively expansive press protections, even for what you might think of as fake news.
Mm-hmm. So let me ask you this then. The First Amendment is the exercise clause of that guarantees a person's right to be exposed to different points of view, different opinions, right? Or the Establishment Clause does that, I guess. Or no, that's the church one. What is going on college campuses? And I'm talking about college campuses that are government campuses that are supported by tax dollars, that are preventing people like a Ben Shapiro or something from coming to their campus and speaking. Isn't that a First Amendment issue?
So first of all, one thing to recognize about the Bill of Rights is that it is only a restriction on government actors. And your hypothetical did say a public school or a state university. I'm a professor at UCLA. We're a state university. And as a state and state university, we're essentially a government agency. And as a government agency, we're obligated now to respect the dictates of the First Amendment and respect the freedom of speech. And so on a public school, public campus, then yes, indeed, you have the freedom of speech, and the campuses are supposed to be places where we have vigorous debates and different perspectives, and people are exposed increasingly to those kinds of different perspectives. That's the idea behind the university. I should note that if you're a private university, say my crosstown rival, USC, which is not USC, a government.
Right.
Yeah, it's not a government university. They don't have the same obligation to follow the First Amendment. They're not bound directly by the First Amendment. And so they can silence sort of who they want, but of course there are principles about academic freedom that are called into question when you take certain speakers and say, you're not welcome on campus.
So how are they getting away with that?
Well, largely they're getting away with it because these people who are being asked not to come on campus are not generally being silenced by administrations and the governing institutions, but often by student groups or the fear of protests by other students. And, as the court has called it, the sort of rough and tumble of free speech is that, yes, free speech protects your right to come onto a public campus and say outrageous things. But it also protects the rights of those who really think what you're saying is outrageous to come out and say outrageous things back and to counter protest. And I think, unfortunately, these days on campus is what we have too much of is too many people are unwilling to hear what the other side has to say. And we've become so tribal and so inhospitable to opposing views that we're finding too often people don't listen to the opposing views at all, and thus don't really have an understanding of what people's motives are and what their thought really is about.
Now, some people think that the president is endangering or violating the First Amendment when he refers to the news media as fake news. What says you about that?
Well, I don't think it. Look, it's not. The president can call it what he wants. He has the freedom of speech, right? And so he can call it fake news all he wants. I think there is at least a reasonable concern that maybe we don't want the president of the United States to be so vigorous in his effort to undermine the basic institutions that we rely on for news. But then again, I do think that, what Donald Trump is voicing is the view of a lot of people in society that they don't really trust our media, and that our media is not, they feel like the media is not doing a particularly good job in informing the public. And even if you don't believe that that it's all fake news and that the media should be intimidated, it's hard not to conclude that the media hasn't really been doing its job as well as it could be.
Now, did the founders consider the media to wasn't there something as far as that almost being a fourth branch of government of sorts?
Well, we think of the media in some ways as sort of a fourth branch. If the three branches are the executive, the legislature, and the judiciary, the media sort of plays an important role in the sense that it can check the government. It exists to expose what the government's doing, communicate that with the people, and that democracy really depends on access to that kind of information about what the government is doing so that we can vote for the policies that we want to correct it or enhance it or do whatever we want to do. And so there is that sort of idea. I don't know that the founders were willing to defer to the press in all circumstances. And it's important to recognize that the First Amendment was in its day only a limitation on Congress's power to limit the press and did not limit states' ability to censor the press. And indeed, before the Civil War, a lot of states, especially in the South, very aggressively censored the media so that it wouldn't promote anti-slavery speech.
Can the state still do that?
You know what Pravda means. Pravda means the truth in Russia, and that's their newspaper, the Russian nationalist, I guess, state newspaper. But our media, our mainstream media here by and large, is kind of the same thing. They've taken on the mantle of liberalism and progressivism, and that's really how they report. So they're not really informing anybody. They're just reporting from a biased position. So that's not information. That's just information from one side. And that happens all the time. And many times it's proven not to be true or it's very biased or anything else. Do they have any responsibility? I mean, I realize how important the news is to the country. I mean, you have to inform your citizens in order to have them to make, good decisions. So when you totally misinform them or you just uninform them, is there any responsibility there and you all of a sudden become Pravda?
Well, I think many of us, including people in the media, believe that there's a responsibility to get it right and to try to do to do a good job on it. I'm not particularly worried about the fact that the media, mainstream media, is liberal. I think actually what we've seen, Chuck, over the last 20 years is the rise of a very, very strong and powerful conservative media alternative that has become very popular and draws a lot of voters. And I think in some ways this harkens back to early America, because in early America
and a few people on the radio. I mean, that's really Oh, shit,
hey, but one of those people is Chuck Woolery, so don't mess around. Okay?
I know, but you understand what I'm saying. They're just not very many.
Right. I don't mean to draw a false equivalence between the two. I only mean to suggest that having partisan media outlets is exactly what the framers were used to. They didn't have objective media. They had, if your newspaper you read was the newspaper of your political party, that's how people tended to look at newspapers. And so newspapers being outrageous and partisan and incomplete and publishing fake news, if you want some good examples of that, just go back and look at the newspapers and pamphlets of the founding era. That's what they're filled with. And in fact, most of American history, that's what the papers were filled with.
The revolution probably wouldn't have been fought if it had not been for those pamphlets.
No, that's right. You had to have some fake news about the King of England to stir up anti-English sentiment here in the colonies. So, hey, if it weren't for fake news, we might not have had a revolution.
So this isn't new. What we're really experiencing today isn't new.
No, I think, so many of us, Mark, we grew up in a time where there were only a few media outlets, and it was kind of this dominant media that was defined at least by an objectivity mantle, even if it wasn't in practice or executed particularly well. But that's not the way media has really been over the course of American history. And you go back to the early 20th century and early 1900s, and you have every newspaper is really a partisan newspaper, and everyone read partisan newspapers. So we're sort of moving back into that era, I think.
What did Randolph Hearst say? Don't argue with the man who buys ink by the barrel.
So is there anything else we need to cover on the first on Article 1 before we move to Article 2? Because we're obviously going to have a lot of conversation about Article 2.
Well, yeah, of course, there's so much to cover with regards to the First Amendment. But I think that we've covered some really important things. One thing that's kind of interesting is the role and the future of the Free Exercise Clause. So this is the clause that says that government shall not inhibit the free exercise of religion. And this is what gives the right of a religious adherent to engage in the practices that are required by their religion, whether it's a Jewish person keeping kosher or whether it's a Catholic person recognizing Lent, whatever that practice is protected. But interestingly enough, in about 25 years ago, Justice Scalia wrote an opinion for the Supreme Court where he said that the free exercise does not protect religious believers from generally applicable laws that were adopted not to stifle religion, but just to pursue some public policy good. And he said, for instance, in that case, that a Native American who had a religious ceremony where they used peyote was not immunized from being punished for using the drug. That even though it was part of a religious practice and it was part of his quote unquote exercise of religion, that because the law was not designed to prohibit religious adherence, but just prohibit the use of the drug, then it was constitutionally permissible.
Hey, listen, where I grew up and came from, people used rattlesnakes. And they got bit by them too. But
yeah, well, the reason I raised that issue is because it's a big issue now with regards to businesses that don't want to serve provide wedding services to LGBT or same-sex couples, because under Scalia's rationale, right, a law of general applicability that applies to everybody, that wasn't written specifically to discriminate against religion, such as a law saying, hey, if you, no matter your sexual orientation, you're entitled to access to the public marketplace. Those kinds of laws, under Scalia's view, the baker and the florist and others who don't want to provide wedding services, they wouldn't find any protection under Justice Scalia's view of the Free Exercise Clause.
Now,
so
are those private companies, though? Do they have an obligation to this since they're private property?
I'm sorry?
Since those businesses are private property and they're not a government entity, they still have to abide by that?
Yeah, for instance, we have laws that say that a private business cannot discriminate on the basis of race and sex. And it doesn't matter that you're a private business, like you can't discriminate on the basis of race and sex in employment. And so what we're talking about are laws that expand those protections that say you can't discriminate on the basis of race and sex to sexual orientation as well.
So now, what about the restaurant that ran Sarah Huckabee Sanders out of the restaurant because she worked for the president and ran her out of a restaurant? It wasn't based on sex. It wasn't based on religion. It was based on where she worked. Mm-hmm. Was that?
Yeah, and that's not protected. Yeah, if the restaurant wants to kick you out because you're wearing a Cubs hat, they can do that. If the restaurant wants to kick you out because they don't like your politics, they can generally do that. The only reason, because they're private property and they have their own rights, the only limitation that they have with regards to how they treat customers is generally a restriction on you can't discriminate on the basis of race or sex.
So if I went in wearing a burqa, they couldn't throw me out because that's covered by religion?
Yeah, often these laws do protect against religious discrimination too, but not all of them.
So that's interesting. So I can throw you out because I don't like your politics. I can't throw you out if you're gay.
If the law says that, right. And so the laws of only, less than 24 states say that, provide those protections for gay people. But all the states and the federal government provide those protections for people to be not to be discriminated on the basis of their race or sex. And those are pretty commonplace and well-accepted policies.
Is there any one thing about the First Amendment that we think we know, but we really don't? In other words, it's something that everybody misinterprets or misunderstands?
Well, I'm not sure if there's something that's been so well interpreted. One thing I emphasized earlier is that it was originally a limit only on Congress and not the federal government, and not the state and local governments, and that's pretty significant. And also this idea that it's important to recognize that the values that we see in the First Amendment were really only first given judicial protection in the 20th century. And that for most of American history, the First Amendment just sort of existed on paper. And it wasn't until the Supreme Court really invigorated the principles of the First Amendment that we developed sort of the First Amendment culture that we have today.
Mm-hmm. Well, let's move on to the Second Amendment, Chuck. And the first thing I want to point out or ask the professor is, when we read the Second Amendment, when we read all of the amendments, there seems to be, I think it seems to be important that we pay attention to the punctuation, to where the commas are, and how we use words like state versus people in different parts of this. Is that a fair assessment?
It's so true, Mark. I mean, you're trying to interpret the text of the Constitution, but the text of many of the textual provisions are written in a way that it's kind of hard to understand because of their grammatical uses, because of the way they used phrasing. And no better example exists than the Second Amendment to the Constitution, which, as written by Madison, says that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. It's almost as if Madison had just discovered the comma and wanted to put it in there as many times as possible. Because it kind of doesn't, I don't know about you guys, but I learned in school that you should be able, if a sentence has 2 commas in it, you should be able to take the material that's out between the 2 commas and the sentence should still make sense. Right. Try doing that with the Second Amendment, and you're going to pull your hair out.
So, what was he trying to do there? What do you think? What was the goal here?
I don't know. Confuse generations of Americans? I'm not sure. I think, look, the goal of the Second Amendment is really, I think, is referred to sort of in the text of the Second Amendment. It's to preserve the right of the people to keep and bear arms, and the reason why they thought that people should have the right to keep and bear arms is because the security of a free state depended on having a well-regulated and armed militia. And remember, at the time, there was no army. Right, the Continental Army had been formed for the Revolutionary War and then quickly disbanded. The framers did not believe in having a standing army because they were fearful that a professionalized army would be used by the president the way the king had used his army in England and would run roughshod over the liberties of the people. Right. So national defense and law enforcement depended on state militias, and these state militias were made up of we the people, of common citizens. Everyone would be a part of the state militia. And in fact, I don't know, Mark, Chuck, we'd all be appearing at some mandatory muster somewhere today, getting prepared for militia service.
Mandatory.
Well, there was. Well, when you think about this, first off, I want people to remember that you have to put this in the context of the date it was written. So that was written by people who just fought what was their legitimate government and defeated them to be free. So obviously they had a lot of fears built in.
Well, Mark, there's another thing that in recent history, I say within the last 100 years, there are many examples, Adam, of like in Germany, the first thing they did, they took everybody's weapons away, and then bam, they had nobody to fight them when the Nazis took over. In Venezuela, they've done the same thing recently. They took away everybody's weapons, and then bam, there's nobody to resist the government. So does that play into anything? That seems to make a lot of sense to me.
Well, I think it's part of the idea behind the Second Amendment and the founders and what they were trying to do. The founders really did believe that it was important to have an armed citizenry. They thought an armed citizenry was the best preservation of liberty, because what they feared was that government would come down, as you say, like in places like Venezuela or in Germany, and come down and subjugate the people. Right. And if we, the people, had firearms at our disposal, we could fight back. But one thing I think it's important to recognize is that the founders were not putting the seeds of revolution and rebellion into the Constitution. They wrote the Constitution to create a government that would last. And I think that the way to think about the Second Amendment is it's not a license for anyone who wants to revolt against the government because the founders did. It is instead this idea that because there's this well-armed citizenry, that the federal government will never go out and impose its burdens on the people, and that we will not have to rise up and revolt. The framers were not trying to encourage people to revolt, and they put down armed rebellions whenever they occurred very quickly.
Well, let's go up to the first comma, a well-regulated militia. Right to that first comma, what does that mean?
What is the well-regulated militia? It's a great question. So first of all, we already mentioned that the militia was the fighting force. If the French were going to come invade, you needed to call out the militia. If the native tribes were going to nearby, were going to declare war on your town, you needed to call out your militia. And the militia was generally made up of free citizens, male citizens, between the age of 16 and 48. Militia laws changed that age a little bit, but that was generally the age category. And if you were a member of the militia, as anyone in that age group would have been, you were required to do certain things. You were, for instance, the founders passed a law just a couple years after the founding that required members of the militia to go out and buy certain kinds of guns so that they could be prepared for war. A lot of people had guns, but they were guns to hunt quail, shot, and that wasn't very effective if you were going to be fighting in a military context. And then those people would have to show up at mandatory musters, and their guns would be inspected. The guns would be registered on public rolls. I know today we think the idea of gun registration is horrible or leads to tyranny, but the founders did that, and they did it because they needed to know where those guns were, not because they wanted to take them away for purposes of tyranny. But if the French are coming and the native tribes are coming, we need those guns, and if you're not going to show up and fight, we're coming to your house and we're taking your gun and we're going to go use it in the fight. And the founders actually did that. There's a lot of evidence of what they called impressment, where guns would be impressed into service, like drafted into service for the Revolutionary War, even if the gun owner didn't want to give it up. But those were weapons of war, and they were needed for protection of the community.
So a lot of people will argue that this doesn't apply today because there is no militia. And some people will argue that the state National Guard is the militia.
Right. I think both those people are kind of wrong, right? So the State National Guard is not the militia as the framers envisioned it, because it's a professionalized, a select militia, not a militia of the whole. That is to say, not a militia of the citizenry at large, which was the idea behind the Second Amendment. And that other idea, that the fact that it's the citizenry of the whole, is part of what the Supreme Court in the Heller decision said was indication of how broad the protections of the Second Amendment were. It's not limited to militia service, but rather we, the people, are part of the militia. So we, the people, have access and have that right to keep and bear arms.
So then we right now are still the militia, even though we're not having a muster.
Kind of, and in fact, there's even a federal law. Mark, I don't know your age, but if you're a bit younger than I am, then you might be a member of the militia under federal law. There is still laws on the books, as in the founding era, that declare people of a certain age to be members of the militia. Obviously, we do not serve in any such capacity. The militias went out of fashion after the War of 1812, so it's been a long time. And I think part of the understanding of the Second Amendment is that our understanding of the purpose of the Second Amendment has changed, that the founders were concerned about the militia primarily. But today we think of gun rights, at least primarily, not exclusively, but primarily in terms of the ability to protect your own liberty in the case of confrontation, in case a criminal comes into your home and you need to protect your home or your family, or if you're on the streets and someone threatens you, you have the ability to defend your own personal liberty, which wasn't exactly how the framers thought of it. Guns weren't particularly useful back then for that purpose.
Now, I do recall reading that was it Jefferson who said that the right to keep and bear arms was the right that all other rights would flow from?
Right. There is some statements about some founders to that effect. And I think the idea, we've said the same thing about the right to vote and about the freedom of speech in time. And we're probably right on several of these fronts, right? Which is that there are some rights that if you do not have, you're likely to lose all the others. And some have said that if you don't have the right to keep and bear arms, then you may lose all of the others. And indeed, if you imagine a scenario like Chuck mentioned earlier, where Germany comes and takes away all the guns and then comes in and commits the Holocaust, well, that's definitely the kind of thing you're trying to avoid. One, of course, there's plenty of countries that don't have guns and don't have despotic or tyrannical government. We can go through a lot of the countries of Europe and Asia. But nonetheless, it's definitely been a fear that has animated gun advocacy throughout American history.
So let's go up to that next comma. So we did a well-regulated militia, comma, being necessary to the security of a free state, comma. What is meant by that phrase?
Well, I think it ties into what we talked about earlier, which was that the purpose of the Second Amendment and giving people the right to keep and bear arms so that they would be able to defend the state and protect the freedom of the state was really an important understanding that
now,
the
when you
founders
say the
had.
state, are you talking about the state of Massachusetts or the state of the nation?
Well, it could be either. We're not really sure exactly what the founders were thinking of when they referred to state in that space. Sometimes the Constitution refers to state to mean literally a state, like Massachusetts or Georgia, and sometimes it means it just to refer to the government. In this context, because the militias were state-based, maybe we might think of it in terms of states. But I think the basic principle holds, right, which is that that the right to keep and bear arms serves to protect a free government. And that was part of the idea behind the founders, and it remains a prominent part of how we think about gun rights today.
Was it Webster that wrote the description of the militia?
I'm not sure which description you're referring to, but if we go back, for instance, and look at the debates over the Second Amendment, and in early America, we now have these tools where we can go back and search large databases of pamphlets, of newspapers, of books written at the time, and you can see how did people talk about something. You can take a word and search it and see every instance where that word is mentioned. What were they talking about? And you see there's just an overwhelming number, but that virtually all of the conversation about the Second Amendment at the time was about the need to preserve these state militias. And that's not necessarily divorced from how we think about gun rights today, by the way, even without the militias, because part of the idea was that the militias would serve to protect our liberties, to act in self-defense of our liberties. And in some ways, even the current understanding of guns is really about protection against common criminals. It's still about self-defense and to protect your liberties from those who want to take them away.
Well, here's where I'm going with that. When I believe it was Webster's definition, when he spoke of the militia, and he spoke of the people that were, men of the age of 16 to 48, and they were required to have a certain weapon and they had a certain amount of ammunition. It stated that it was all able-bodied men between 16 and 48, but then it said except some certain federal officials, I believe. So why were we exempting federal officials from being considered part of the militia?
Well, I'll confess I'm not familiar with that particular pamphlet or that particular argument, so I don't really know exactly what Webster was getting at in that point. I will say that there was, again, part of the whole motivation behind the Bill of Rights from the First Amendment and the Second Amendment on was about protecting against federal tyranny, about providing the mechanisms and the means and the guarantees to ensure that the federal government would not grow too big and not grow too powerful. And given that the Constitution did give Congress, under the structural provisions, to call forth, to arm, and to discipline the state militias, so it gave Congress the power to oversee those militias, that maybe there was an argument, the argument was being made that we need more separation between the state and militias and the federal government in order for the Second Amendment to do its work.
Yeah, what I read was that the purpose in that was to make the militia have a separation from the federal government. And there were also writings that said that the militia, that a standing army should never be better equipped than the standing militia.
Well, you throw that out the window. I'd hate to use my 22 against an F-35.
That's right. We learned that lesson pretty quickly, by the way. The War of 1812 was the death of the state militias for the most part. And what happened when the War of 1812, if you recall that from your history class, that's when England came back and decided they were going to refight the revolution and take back America, and almost succeeded. They ended up burning down Washington, D.C. and capturing some territory before losing. They lost largely because of what was happening in 1812 in Europe at the time, Napoleon, and they were fighting Napoleon, and that became a more existential threat than what was happening here in the New World. And what happened in the War of 1812 is that a lot of states, because we didn't have a standing army, the states had to send their militias to the fight. Right. And a lot of states just refused to send their militias. And it was a total disaster. And like I said, they burned Washington to the ground. And after that, the Americans, we kind of realized, hey, we can't rely on states to voluntarily send their militia people to fight these battles, because, hey, we all know, Chuck and Mark, that Americans can't really agree on anything these days, much less putting their people in the way of gunfire.
It's not just Americans. Hey, listen, I heard a story, and I'm not sure whether this is historically accurate or not, but if it isn't, maybe you'll know the difference. Did you ever hear the story about when the British came into Washington, D.C., we had no defense at all. I mean, we were trying our best, but that was a losing battle. And during that time, or right after they burned down the White House and everything else, this tornado came through and just basically wiped out the British Army. Is that historically true, or do you know?
I can't say I'm familiar with that story, but, hey, divine providence has always been on America's side.
Yeah, I mean, I heard that and I went, wow, how interesting is that? But,
So let's go to the next part. So the right of the people to keep and bear arms, comma. And again, why the comma there? Why this comma before saying shall not be infringed?
Right. I mean, it's like, what are we supposed to do with this comma? It separates the subject of the sentence from the verb. I don't understand what we're supposed to be doing here. But mostly the courts have said that sort of looked over that comma and said that it basically says the right of the people to keep and bear arms shall not be infringed. Mm-hmm. Now, some people see the Second Amendment as only protecting a right associated with the militia, right? We already talked about the militia clause, and the militia did play an important role in the founders' ideas of the Second Amendment. But part of the problem with that argument is that we have this language, the right of the people to keep and bear arms. And when the Bill of Rights refers to the people and rights of the people in several different places, including the First Amendment, the right of the people to assemble and to petition government for redress of their grievances. Things like the Fourth Amendment, the right of people to be secure in their papers, houses, and effects from unreasonable searches and seizures. This language has always been interpreted to mean the right of individuals as people to have those rights. And so it would be very odd if the founders put into the Bill of Rights protection for the rights of people, by that which they mean individual rights, in the First Amendment and the Fourth Amendment, but some sort of collective right that's not an individual right in the Second Amendment using the same phrase. It's kind of a bizarre theory of interpretation.
Yeah, I've been told that if the Founding Fathers really meant that the right to keep and bear arms belonged to a formal militia, that it would have said the right of the state to keep and bear arms, not the right of the people. And we see security of a free state, comma, the right of the people. So it seems it was very deliberate to call out what was a state issue and what was a personal or belonged to the citizens. Would you agree with that?
Yeah, I think that's right. Although I will say, I think this divide between an individual right and a right that's associated only with service in the state militia, the founders weren't even considering that kind of, those two different options. They all thought it was kind of the same thing because, again, there weren't efforts to guns were served a different purpose at that time. And so the founders probably didn't distinguish between an individual right to have a firearm and an individual's right to have a firearm and serve in the militia. It was all part and parcel of the same thing. One thing to note is that the Supreme Court was very clear that the Second Amendment, and that phrase that we've just been talking about, the right of the people to keep and bear arms, it protects two different rights, not just one. It's a right to keep arms, a right to have and possess arms in your home, but also a right to bear arms. That is, the Supreme Court said in the Heller case, a right to carry guns in case of confrontation. The Supreme Court still has yet to figure out and to sort out what are the restrictions and limits governments can impose on your ability to carry a gun in public. But it seems pretty clear that the Second Amendment protects a right to have a gun both in your home and, at least in some contexts, a right to have a gun outside of the home.
Well, with Kentucky now just making constitutional carry, we now have 15 states who now just respect constitutional carry and do not even require a permit to carry a gun.
I grew up in Kentucky, and I'll tell you what, that didn't prohibit them from carrying them when I grew up.
So here's another question that we hear from I'll say the left. I hate to use the term left and right, but from the anti-gun lobby. One of their big arguments, besides for the militia argument, is that the founding fathers didn't understand what an AR-15 was or what a semi-automatic pistol was. They only knew what a musket was.
And a cannon.
And had they known what an AR-15 had been, they wouldn't have written this the way they wrote it.
Well, it's such a counterfactual. I just blow off those arguments. There's not much you can say about that. I mean, you could say the same thing about the Fourth Amendment. Well, if they knew people were going to use illicit drugs like PCP, then maybe they wouldn't have a Fourth Amendment that provides protections against unreasonable searches and seizures. They'd allow government to come in and seize people's drugs. Or maybe if they had understood that there was pornography that would be promoted by the freedom of speech, then they wouldn't have written the First Amendment to protect it. I don't know what to say about that other than the Supreme Court has been very clear over the years that a constitution protects principles, not technologies. And as a result, we have to keep the principles alive even as technology changes. And just like we have to reimagine the First Amendment principles, or not reimagine them, but translate them and apply them to a context like the internet, to things like digital pornography, to a world in which there's different kinds of forums and platforms for speech than the framers could have ever imagined, we still have to do the same thing with the Second Amendment. Figure out what is the core principle that's protected by that amendment and translate it in some ways into the modern technology. No, they couldn't have imagined an AR-15 or whatnot, but that doesn't mean an AR-15 is not an arm that's protected any more than the internet was not a matter.
Right. They couldn't have imagined television, radio, and the internet, or they couldn't have imagined Scientology.
Well, that's for sure.
Well, think about it. Freedom of religion. What were the religions that were in their wheelhouse at that point?
Right.
No, that's right. I think that the founders could not have imagined a lot. I mean, we tend to glorify the founders, and maybe for good reason. They are our founders. They are part of our origin story, and they've certainly given us a document that has governed us. I don't know if I'd say it's governed us terrifically over the years. I mean, we did have a civil war, and we've had a lot of problems over the course of 200 years. But it certainly gives us a document to respect and to try to think about critically in terms of what are the values and principles of government that it lays out. And they did a pretty good job at that.
Well, I would say it has been the cleanest dirty shirt in the hamper of the history of man.
The cleanest dirty shirt in the hamper. I like that.
So since we got an extra minute here, I'm going to knock off Article 3 because that's only going to take you a minute to deal with.
I think we're basically done with Article 3 already then. So Article 3, so people know, it's a protection that prevents against the quartering of troops in your home. And the idea is that the government can't force soldiers to live in your home and force you to feed and clothe them. And you say, well, why would this ever happen? But it turns out this was a big issue. Again, the Bill of Rights reflects the concerns of the founders. And the founders were really concerned with this issue because the British government had done just that during the Revolutionary era.
But it was done all over Europe during the Second World War.
Yeah. Oh, yeah. It was done over Europe in the Second World War too. That's right. This is something that happens sometimes. It's happened sometimes in warfare, but it's never really happened in American history since the Constitution was adopted, and indeed the Supreme Court has never, in its over 200 years of aggressive judicial review, has never once heard a Third Amendment case. So it's constitutional language that has been upended by the passage of time.
I have a very good friend of mine named Sam Chew, and Sam Chew's family goes back before the founding. And when George Washington was rolling through Pennsylvania, the Chew Mansion was there, and he decided to go around it as opposed to some of his generals that said we should go through it because the British were in the Chew Mansion, and they'd taken it up, and they had a big stronghold there. It was a huge place, an enormous house that still stands today in Pennsylvania. But it just so happens that my friend's family owned it.
Oh, my.
Yeah.
Well, Professor Winkler, as usual, thank you. This has been, amazing. I love these episodes. Folks, we want to keep in mind that if you're looking to learn more about the professor, go to the show notes at bluntforcetruth.com. And you'll find links to everything about Professor Winkler, including links to be able to get several of his wonderful books, which are really great, by the way. And we will have you back next month. And next month, what are we going to cover, Professor? How many articles are we going to do next month?
Well, I think what we'll do is we'll sort of dive into, since we did 1, 2, and 3, we should probably look at 4, 5, and 6. Maybe we'll throw 7 in there because it's so intimately related. We think of the Bill of Rights as protection of our fundamental rights of conscience and religion and speech and the right to bear arms like we talked about today. But most of the Bill of Rights is really focused on a different issue, which is the investigation, prosecution, and punishment of criminals. And that's what we're going to get into with the next few amendments.
Adam Winkler, thank you so much. Really appreciate it. It's been a great day and a good lesson. And that's it for us on Blunt Force Truth. Thanks for everybody for joining us, and we'll see you next time.